Okay, thank you. Good morning and welcome to Quantuma's second joint webinar with IBB Law. I'm Ian Barton and I'll be your chair for today. In this webinar, we'll look at options for the stressed business owner, the considerations that they face and the next steps that they can take, with a particular focus on an accelerated disposal process, whilst providing clarity on various other issues and viable pathways that they can potentially follow. The Q&A function is open on this webinar, so please do feel free to submit your questions in real time. And we'll do our best to get through as many of those as we can before the end. Before we kick off, I'd just ask for your patience if we do have any experienced difficulties technically in the next hour or so. And without further ado, let me introduce you to today's speakers. First up, we have Philippa Robinson, who is a director in Quantuma's corporate finance team. Philippa has significant experience of working with small and medium-sized enterprises as their trusted advisor. She has worked on a variety of transactions and is well respected amongst her wide and loyal network. Following on from Philippa, we have Adam Dowdney, a partner at IBB Law. Adam is a well-known and experienced corporate and M&A lawyer in the Thames Valley and West London. He works on all aspects of corporate law, including mergers and acquisitions, MBOs and MBIs, private equity, venture capital transactions. Adam's respected for his constructive and commercial approach and is included in the Legal 500 Hall of Fame. Following on from Adam, I'll look at accelerated M&A from the perspective of the buyer. And then completing today's panel, we have Marc Jones from IBB, who's a commercially minded and results-driven lawyer who focuses on providing prompt and pragmatic advice on people issues. He has specialised in all areas of employment law and human resources for over 20 years, with extensive experience in dealing with whistleblowing, restrictive covenants, executive terminations, and employment tribunal claims. Marc is a qualified workplace mediator and sits on the editorial board of the Employment Lawyers Association's ELA briefing. So having introduced the speakers, I'll hand over to Philippa to start the discussion. Philippa.
Thank you, Ian. Good morning, everybody. I still can't get used to this not being able to see anybody, but I hope that out there are some friendly faces smiling at me. Anyway, as Ian said, I'm from the corporate finance team within the Quantuma business, and I've enjoyed working with SMEs in all sorts of capacities for over 20 years. As such, I've become used to helping business owners assess their options in different situations and come up with plans. Of course, normally, I'm used to knowing these businesses for a period of time, and in many cases, I've been part of their journey that's got them to where they are now, so understand how their decision-making process has worked. This is a rather different situation. So how as a team are we helping these kind of business owners quickly identify what to do next? May we have the next slide? The picture that we build up needs to focus on all sorts of areas of the business, not just financial ones. It needs to understand how business really operates. You really need to be under the skin of the business to understand what's important. And also, it's really important to understand what are the key drivers of the people who own the business or work in the business or are invested in the business. So, as I said, at the moment, we're being approached by lots of businesses that we don't really have the luxury of having had the time to get to know. We need to act fast. We're also being asked for help by other advisors who in turn are trying to help their own clients, so we may not meet the business at all. This led us to think that it would be good to formalise the process that we would go through in our heads using our experience so that other people can do the same thing. So what we've tried to do is produce a suite of tools that we think might help our clients and also our referrers be able to help their clients. I think Adrian mentioned last week, one of those tools is an application form for a CBUS loan, which just prompts business owners to be able to see the sort of things that they might have wanted to included in their application that they might not have thought. In this vein, we've also produced a diagnostic tool. I think we can see on the screen. It may be a bit small for you to be able to see, but it starts off with a questionnaire that we send out that people can gather the information together that we need. I think the main purpose of this usually identifies that actually they don't have the information that we need. But anyway, there's a number of questions here you can see, things like, is there a 13-week rolling cash flow? Does the business have detailed monthly forecasts that include some cash flow projections and movements in working capital? And quite importantly at the moment, what is the weekly cash burn now that maybe you've mothballed your business? There are obviously certain things that you still have to pay. So there's also other areas that are asked about, not just financial, for example, employees, a section on key suppliers. Can we move on to the next slide? So once the responses are collated, like I say, this usually points to the fact that actually they don't have the detailed financial information that's needed. So this is an area where we've got many, many years of experience of helping businesses to put together projections. So we can do that really quickly. And, you know, it's really important that businesses actually understand their cash burn and how they're going to get on through this. So what I think the main thing I've seen from the sort of questions these questions that we've been asking people over the last few weeks is that actually the biggest issue that people are going to face is that once they get back to whatever the new normal is, there's going to be a big lack of working capital. Now, that's been caused by all sorts of things. So a number of businesses I work with are in the construction space. So December, January and February for them usually are their worst months of the year anyway. This year there was extra rain, so much rain in January and February. So they've really gone into this with a much depleted cash flow balance to start with. So that's really giving them an issue when they're trying to work out how to come out of it. Other people are finding that, who are funded by invoice discounting lines, are finding out that the people aren't paying quickly enough. So unfortunately, money that's coming in is also having to go to fund a reducing balance that they're able to use. Some debtors that were funded might now be in a riskier position, so the funder might be taking a different view on who they'll lend against. And other people, customers are becoming insolvent, which is putting further pressure on cash flow. Another issue that I think businesses are facing is that key suppliers are unwilling to commit to future supplies because they're still owed money from previous supplies. We've done a number of things with these sorts of instances where we've made payment plans and we're taking smaller deliveries on pro forma invoices, for example. I've also got a client who won't be able to service their clients when we do get back to the normal because their labour was all foreign and it's all gone home. Anyway, once we've collected and assessed all this information, the key then is to develop a coherent approach to enable the shareholders to develop a plan with defined steps to move forward. Sadly, it could be that the business is in too much trouble to continue in its current guise, and for that we have a team of extremely commercial IPs who can help to restructure a business so that a future may be possible. In other cases, it may be that an injection of funds can solve a short-term problem, and with careful cash management, the business can get back to whatever is the new normal. Adrian mentioned CBILS last week, and of course there are other sources of debt that we can help businesses to access. I'm sure Adrian stressed this, but what is key is that any debt request is matched by detailed information that shows the amount being asked for is sufficient, not too much, but enough to get through the issue, and also that the business can in time service and repay the debt. It could be that now is the time to find an equity partner to inject some cash, so that the business has a firmer foundation to stand on. We all know about the man who built his beautiful house on the sand and then realised that stone might have been a better option. Debt may seem cheaper than equity, but if it results in a cash-strapped business that has to use all its profits to service that debt, there may be no cash left for growth. Private equity investors, if you choose the right partners, can add all sorts of value, as well as providing patient capital. It may also be that this period has changed the desires of the shareholders. They may no longer see building their business as their main goal. They may feel that this is the time to sell. Obviously, normally we would just conduct a sales process with plenty of time. However, at the moment, this business may be stressed. So I think Adam's going to tell us about how he would manage an accelerated M&A process.
Well, thanks very much, Philippa. Morning, everybody. I think as Philippa has alluded to, companies that currently are finding themselves in financial difficulty often see a disposal of the company or of its assets as the best exit route for all of the stakeholders. And I think it's important that we bear in mind it is all of the stakeholders. Often it's going to be the creditors that will encourage an exit through some form of disposal process because they can see little prospect in recovering the debts outstanding in any other way. So the decision to sell may well be driven, at least in part, by creditor pressure. An accelerated M&A process really is almost identical to a more traditional sale process. But the most significant difference, again, as Philippa alluded to, is the timescales involved. A normal M&A process from marketing through to completion can take a number of months, with significant negotiation, due diligence being undertaken, etc. An accelerated M&A process from the teaser or information memoranda to completion is more likely to be a matter of weeks, or possibly, depending on the state of the business, even days. It's also worth bearing in mind that most AMA processes result in the sale of the business and assets rather than the shares in the company, because a buyer is more likely to want to cherry pick some of the key assets and leave behind some of the worst liabilities. And a number of those are through some sort of insolvency process or pre-pack. As we looked at last week, I think the danger is, as we come out of lockdown and some of the government-assisted programs, that many companies may find that the damage done to their business is too great for them to be able to recover. And although the underlying business may be viable, creditor pressure and damage to cash flow will require some form of AMA process to be undertaken. It may well be the only way the creditors can be repaid, and indeed some form of value can be given back to the shareholders. And who will be the buyers? Well, they'll probably come from two different approaches. There'll be the opportunistic buyer who have managed to stay cash positive during the crisis and see the opportunity to consolidate in their market by acquiring a competitor and thereby increasing their capacity and their market share, or indeed possibly diversifying to provide greater bandwidth and strength and depth within their business. And I think then there will also be the defensive buyers who see liquidity issues in their supply chains and decide the best way of ensuring supply to their customers is to effectively take their supplies in-house. So a few points to consider as a seller if we can look at that from an AMA process from a seller's perspective. I think like any disposal process, preparation is absolutely key. Make sure you've got a full NDA in place, particularly if you are potentially selling to a competitor. And if there are heads of terms drafted, make sure they deal with all the key issues as you see them. I think, again, as Philippa has alluded to in going through the sort of process that she set out, understanding the key issues of your business and how they impact the performance is absolutely critical. You need to understand your cash flow, your projections, your management accounts, etc. Make sure your assets are where they should be, and by that I mean from a legal and from a physical perspective, and all your asset lists are up to date, your IP is where it should be, is freely transferable, etc., etc. If you have a group structure, make sure you know which asset sits within which company within the group. That's going to be very important to a potential buyer. And be prepared to discuss why the business is struggling and have properly defendable and diligently prepared answers, which can be scrutinised and will be scrutinised further down the line. And do also be prepared for any price negotiations. As the buyer becomes more aware of the actual state of the business, it may be they will use some of the issues as opportunities to try and negotiate the price. So do be flexible and be aware and be prepared to accept and enter into price negotiations. And do make sure critically that the buyer has got the funds. Some form of proof of funds is absolutely critical. You don't want to waste valuable time and effort and resource in negotiating with a buyer who can't actually undertake and carry through the process. I think this is where Philippa and their team can come in. Clearly understand all of the options available. An AMA process covers a number of different potential routes. There's a share sale, a sale of the business and assets, some form of debt refinance or equity investment, a sale of the debt, or as we've talked about, a disposal via some form of insolvency mechanism. And I think the process may change as time goes on and as buyers come and go. So do be aware of all the potential options that are out there for an M&A process, an AMA process. I would say this, but I think it is critical to appoint professional advisors who are experienced in running this sort of process. Given that many accelerated M&A processes end in insolvency or some form of insolvency event, a firm with restructuring expertise, I think, is pretty important. Start building your data room as early as you possibly can. I think full and easily accessible information for potential buyers is key to maximising the value you can get from your business. The extent and quality of due diligence is critical to the buyer, because any protection by way of warranties and indemnities in an accelerated M&A process is going to be limited. Even in a solvent sale, any post-sale recourse is likely to be limited in the longer term. So a buyer's ability to really get under the skin, as Philippa talked about, of the business and understand what the issues are is critical. And if you're providing all this information, make sure you're available to respond, to supplement information, to answer questions from potential buyers. Availability and being prepared to respond quickly is absolutely key. And again, around understanding your business, make sure you understand your key contracts. Contracts can be terminated, often on an insolvency event, or maybe assignable, or need to be assignable if you're going through a solvent M&A process. So you do need to understand who your key contracts are with, whether they're coming towards the end of their lifetime, whether a novation is required. A third party cannot be compelled to enter into an novation or a new contract with a buyer, so you may need to enter into discussions with your key contracts, key third party contractors early in the process. It may also be that stock is held subject to retention of title provisions, and valid claims could significantly reduce the value of stock for a buyer or create cash flow issues for a buyer. So make sure you understand the contractual position with your key suppliers and customers, and as I say, it may be that you need to undertake conversations with them during the AMA process. Employees and TUPE, and Marc will come on to look at this in more detail in a while, but be aware upfront of your notification and consultation obligations, and also be aware that once discussions have started with a potential buyer, you can't further reduce your workforce without the dismissals almost certainly being deemed to be unfair, and there are costs associated with that. Encumbrances. Do check that any appropriate releases will be obtained from existing funders who may have debentures or charges over the assets being acquired. And I think generally make sure that any third-party consents that are required for the disposal of any assets have been obtained. In particular, consider your premises from where the business operates. It is likely the business is going to need to operate from its existing premises to continue trading, at least in the short term. So discussions will need to be had with the landlord to ensure some form of continuity. As we've stressed, it's likely any deal is going to happen very quickly. So there's unlikely to be time to secure an assignment or a new lease. So some form of license to occupy may need to be required. Absolutely critical to keep your key stakeholders, particularly your financial creditors, informed of progress. You need to keep them up to date as how the process is going, particularly if what they're receiving doesn't represent full repayment. Their buy-in to any sale process, any accelerated M&A process is absolutely critical. Keep your deadlines short and stick to them, and also make sure buyers stick to them. Time is critical in this process. There may be a little bit more time than you realise to negotiate certain things, but make sure when you've given a deadline you stick to it, and that the buyers do as well. If you don't stick to them, it does make management of the business increasingly difficult during what is already a stressful time. Don't lose sight of your duties as directors. We talked about this in some detail last week, but if there is potentially an insolvency at the end of the process, directors' conduct will be very closely examined. So do take advice on your duties regularly. Keep a record of decisions made, of the advice you've taken, as we discussed last week. I think that's absolutely critical. And finally, be flexible. The outcome of the AMA process is uncertain and may not actually be known right until the very end. You'll be asked to consider a wide range of consideration structures, of deal structures, etc. So do be prepared to negotiate. Don't get too high or low during the process. There will be ups and downs. try and keep yourself on an even keel. Right, I think Ian's now going to try and look at it, or he's going to look at the process from the perspective of the buyer.
Thanks, Adam. As Adam says, I'm going to slightly turn that on its head, and rather than, as Adam has done there, talk you through the perspectives from a seller in an accelerated disposal, but I'm going to look at it from a buyer. And, you know, our experience is that in recent weeks, businesses have been dominated by rescue culture thinking. I'm going to look at the timing and approach, and then I'm going to give you a few thoughts on pricing and buyer beware issues as well. So there's been lots of commentary in the media and professional services about insolvencies, and these are going to be increasing. But the fact is, at this time, most businesses are in cost down mitigation measures and cash management. Most have taken those more straightforward steps, either delaying payments to HMRC for VAT and PAYE, undergoing furloughing procedures, negotiating on rents and rates, taking out CBILS loans. But where they can, they've done that. But now it's the uncertainty of the length of recovery that's causing businesses to assess their viability and future options. As a result, owner fatigue and the weight of personal guarantees where they're in place on businesses will eventually force sales at value, unfortunately. And this is going to be an issue for several months. It's not just an instant issue. And that'll come down to the weight of borrowing, and also, as Philippa talked about, the return of working capital as overheads increase as businesses reopen and revenue builds slower than they would like. And then as you get into early 2021, you'll have the repayment of those delayed creditors as well from HMRC. So it's very likely that this is going to be a buyer's market for the foreseeable future. Next slide, please. So thinking about timing, there is always a pre-appointment opportunities. You begin to try and work out your options, and Philippa has walked us through some of those. As a buyer, if you think that there is an opportunity for you, take the opportunity to register interest with that business. An administrator is always going to approach the known parties first. And if you've got your foot in the door initially, then you're going to get the phone call when they're considering their options around an accelerated disposal. As Adam referenced, that there may be slightly more time than you think as an acquirer. You know, there's a 10-day period known as a notice of intention to appoint, when between filing at the court and actually the administrating taking place. And of course, there's the pre-appointment period as well. Even after the administrator's been appointed, insolvency practitioners are pragmatic people. They want to get the job done, they want to save jobs, and of course, they want to secure a fee. Don't expect perfect numbers, but ultimately that's going to be reflected in the offer that you make for the business. Choose what you want to buy. Are you going to buy the business and assets? Are you going to buy all of the business and assets, or are you just going to buy a selective amount of them? Are you just going to buy the intellectual property in the business? Are you going to buy the debtor book? Or are you just going to do a collect out on the debtors and pay that back to the administrator over a period of time? Most of all, it's about protecting yourself from inheriting unwanted liabilities. There's going to be no warranties here, save for title to deliver the business. Most of the liabilities will be left behind. As a result, you should have a very straightforward asset purchase agreement and a quick execution. Critical at that point to make sure you're getting the right legal advice around what to buy, what you don't want to buy, and how you protect yourself. IPs are going to get busy, and they're not going to have necessarily the time to run extended processes to deliver enhanced value to creditors. Whilst the legals are straightforward, advice is going to be crucial. But probably most importantly, as a buyer, sometimes it's better to get the deal done at a reasonable price than to try and hammer out a process. This is all about getting control and moving your business and the business that you're acquiring forward. Next slide, please. So thinking about pricing, fundamentally, you've got to throw away all previous ideas of valuing of an equivalent business. This is essentially an asset purchase. And one thing to remember, therefore, is that VAT is likely to be paid on the price. So you need to factor that into the costs on day one that you need to fund. Thinking about some of the assets that you'll be looking at here, you know, fixed assets, these are going to be at market value, maybe a bit cheaper, but fundamentally they're going to be subject to an independent valuation. As Adam referenced, on stock and inventories, look out for retention of title clauses. They might be 15 or 25% of the book cost, maybe cheaper, but fundamentally the chances are that you're going to have to take the bad with the good. In terms of debtors, look to get control of the customers. If you're going to do a collect out, you might typically charge 20 or 30% of the ledger for that collection service, but it's all about negotiation. More importantly, it's about the other aspects, such as conduct of claims. If people don't pay, who runs that claim procedure? Is it you as the collector, or is it the administrator as the holder of the debt? Priority of cash allocation. If you've inherited that customer, because that was the purpose of doing the collect out, of course, and you do work for that customer and invoice them, make sure that the cash paid for your work is allocated to your invoice and not to the administrators. And time limits. This won't go on forever. Think about how long you're prepared to do this process for and what happens when that process comes to an end. For properties, the IP will typically grant a license to occupy, typically maybe up to 9 months to stabilise the business and allow you to negotiate a novation or a new lease with a landlord. But you've got to pay the rent, and chances are you'll have to pay it up front because you'll be a new owner. Supplier relationships are fundamental to keeping the business going. You may have to make ransom payments to ensure continued service as you build up your trade credit. Management incentives, like in all businesses, the management will have been through a tough period as the business has gone through its options and potential insolvency. So incentivizing management is going to be key. You may need to realign them via potentially a small equity stake or bonus arrangements to keep them on board and to keep them motivated. Fundamentally, it's about the value to you, less the risk that you're going to be asked to inherit. As a buyer, you've got the advantage. Be cheeky, but establish dialogue with the administrator. Remember, conditionality of the payment that you make is going to be less attractive, so cash up front is going to be a better option for an administrator. But you don't need to pay it all on completion. As Adam referenced, cash is king, and proof of funding will be absolutely crucial as a buyer to establish your credibility with an administrator in an acquisition. Most of all, be well advised. It protects the value for you, and it also shows the administrator that you're serious to act. Fundamentally, if the administrator believes that you understand the process, both from a legal perspective and from a financial one, they will have the confidence to engage with you further, and that will enhance your position as a buyer. Next slide, please. So a few final thoughts on buyer beware. Make sure you get what you want. Understand where the value in the business lies, especially around intellectual property, patents, licenses, franchise arrangements, customer and supplier agreements. As Adam said, many of these may terminate on a formal insolvency, and there are no warranties. It's therefore riskier as a buyer to buy poorly than in a normal type of deal. A cheap price doesn't always mean a good deal. Customer retention. Fundamentally, this is one of the reasons probably that you're buying the business anyway, to get control of that. But remember, your competitors are chasing them too. So it's about getting control of the process and doing it quickly. The longer a process runs on, the more risk that those customers will go and find other people that can provide services for them. If you're buying out of a large corporate, it may well be that there are significant pension liabilities, potentially it still has a corporate defined benefit scheme. You don't necessarily need to run a mile in those situations. Here at Quantuma, we've got a specialist pension advisory service that can help work through those situations for you. Clearly it's a challenge, but it's not an insurmountable one. Thinking about work in progress. If you want the value from it, you're going to need to complete it. So make sure you've factored in the cost of doing that as part of the purchase price that you're prepared to pay. As Philippa said, working capital here is going to be key. ransom payments potentially to key creditors as you build up your credit position, time to rebuild the debtor book. It's likely that debtors will stretch out their repayment terms, and so you need to factor that in to your cash flow forecasting. If there's machinery used in the business, particularly if it's leased, you're going to have to expect to refinance it or run the risk of repossession. But there's going to be deals to be done, and there might be a number of different finance organisations that you have to deal with to sort out those leases. Timing. It's key to think about and minimise those initial cash outflows post-completion. Check when the wages of any transferring staff have been paid to, for instance. The best advice is to have a 13-week cash flow and to factor in all the things that I've just talked about, and make sure that you've got enough headroom for when things don't quite go as you initially planned. Most of all, and perhaps the biggest buyer beware issue, is around employee considerations and TUPE, because that's a key area of risk in any accelerated M&A process for a buyer. And Marc is now going to take us through some thoughts on that.
Thank you, Ian, and good morning, everyone. I'll be dealing briefly with share purchase, and the focus of my talk is going to be on an asset sale. Next slide, please. On a share purchase, the status quo remains as the buyer simply slips into the shoes of the seller. There are no direct employment law considerations unless post-purchase integration is proposed involving management and reporting lines. If there is, then TUPE could apply. You can change terms and conditions of employment post-purchase, but you would need to consult with the acquired employees and obtain the agreement of those employees about the change. Next slide, please. So onto asset sale. I'll be dealing with the three employment law considerations. They're TUPE, that's the Transfer of Undertakings and Protection of Employment Regulations, redundancy, and furloughed employees. Next slide, please. Regulation 4 deals with contracts of employment. That means all the seller's rights, powers, duties, and liabilities under or in connection with that contract shall be transferred to the buyer. Any act or omission of the seller before the transfer is completed in respect of that contract shall be deemed to have been an act or omission of the buyer. The seller will become the employer of the affected employees. Any variation of the contract will be void if the sole or principal reason for the variation is the transfer, unless it is for an ETO reason, which I'll get onto later on, entailing changes in the workforce, or the terms of the contract permit the buyer to make such a variation. Then with insolvency, TUPE does not apply where the seller is the subject of bankruptcy proceedings or any analogous insolvency proceedings, which have been instituted with the view to the liquidation of the assets of the seller and are under the supervision of an IP. At the time of a TUPE transfer, the buyer normally assumes the responsibility for all matters under or in connected with the employee's contracts. However, in the case of relevant insolvency proceedings, certain sums outstanding at the date of the relevant transfer will be met from the National Insurance Fund rather than by the buyer. Relevant insolvency proceedings for the purposes of TUPE are those businesses that are on the critical list but still breathing under the supervision of an IP, such as administration, voluntary arrangements, and administrative receivership. If at the time of a relevant transfer, the seller is subject to relevant insolvency proceedings, TUPE shall not prevent the seller or the buyer or an IP and appropriate representatives of assigned employees agreeing to variations of the contract. Employee liability information. The seller must provide the buyer with ELI in writing at least 28 days before the relevant transfer, and that must specify the identity and age of affected employees, those written particulars of employment that an employer is obliged to give an employee pursuant to Section 1 of the Employment Rights Act, details of any disciplinary procedure taken against affected employees, details of any grievances taken by affected employees, information of any court or tribunal claim or action brought by an employee against the seller within the previous 2 years, if the seller has reasonable grounds to believe that an employee may bring a claim against the buyer relating to his employment after the transfer, and any collective agreement which will have the effect after the transfer. On to inform and consult. This must be done at least a month before the transfer. Both the buyer and the seller must inform and, if appropriate, consult with recognised trade unions or elected employee representatives if there is no recognised union. In relation to any employees who may be affected by the transfer, there will be a duty to inform on every TUPE transfer. The duty to consult only arises where an employer envisaged taking measures in respect of the affected employees. So when we inform affected employees, this must comprise of the fact of the transfer, the date or proposed date of the transfer, and the reasons for it. We must specify the legal, economic, and social implications of the transfer. We must specify the measures envisaged in connection with the transfer in relation to affected employees, or, if no measures, that fact. And also the measures relating to the transfer which it envisages the buyer will take after the transfer, or if no measures will be taken, that fact. Micro businesses with less than 10 employees are able to inform and consult affected employees directly in certain circumstances. Failure to comply with the obligations exposes the seller and the buyer to pay compensation equivalent up to 13 weeks uncapped pay, as they could be held to be jointly and severally liable. Election of representatives. There must be a sufficient number of representatives to represent the interests of all affected employees, which is determined by the employer seller. The term of the employee representatives must be sufficient to enable information to be given and consultation completed. All employee representatives must be affected employees on the date of the election. No affected employee should be unreasonably excluded from standing for election. All affected employees on the date of election are entitled to vote for employee representatives. And the election should be conducted as far as is reasonably practicable to ensure voting is in secret and accurately counted. Next slide, please. It will be automatic unfair dismissal if the sole or principal reason for the dismissal is the transfer. This applies to affected employees dismissed by the seller before the transfer, affected employees who transfer to the buyer and then dismissed by the buyer, employees in the buyer's existing workforce who are dismissed as a result of the transferring affected employees to the seller. But as with ordinary unfair dismissal, those affected employees need 2 years continuous employment to bring a claim. Economical, technical, and organisation reason. that entails changes in the workforce will relate to the location, number of employees, and functions performed by those employees. This overlaps with redundancy under Section 139 of the ERA, which is when the requirements of a business for employees to perform work of a particular kind, whether or not in the place they were employed, has ceased or diminished, resulting in dismissals. The onus will fall on the employer pre or post transfer to show that the dismissal is for an ETO reason. If not, the dismissal will be automatically unfair. And normal considerations apply to reasonableness in relation to the fairness of the dismissal. And that means applying a proper procedure under Section 98(4) of the ERA. If the buyer or seller proposes to dismiss as redundant 20 or more employees at one establishment within a period of 90 days, collective consultation must take place. If the buyer and or the seller fail to collectively consult, they could be liable to pay a protective award of up to 90 days uncapped pay for each affected employee. Again, they can be held to be jointly and severally liable. Next slide, please. Can administrators furlough employees? Well, the Court of Appeal has recently dismissed an appeal against the High Court's direction to the administrators of the high street retailer Debenhams in relation to their potential liabilities to employees furloughed under the coronavirus job retention scheme. It agreed with the High Court that if the administrators pay sums received under the CJRS to employees who had already been furloughed by the time the company went into administration, they will be taken to have adopted the contracts of employment under paragraph 99 of Schedule B1 to the Insolvency Act. Therefore, the monies paid under the CJRS can be paid to employees in priority over the administrator's fees and expenses and the distribution of assets to floating charge and unsecured creditors. Does TUPE apply to furloughed employees? Yes, the buyer as the new employer is eligible to claim under the CJRS in respect of the transferred employees after the 19th of March 2020, if either TUPE or the PAYE business succession rules apply to the change in ownership. Lastly, can furloughed employees be dismissed by reason of redundancy? Well, the guidance for employees states an employer can dismiss employees by reason of redundancy while they are furloughed. If they are, then the CJRS grant would end, and this suggests that both the consultation process and notice can be provided while employees are furloughed. Again, a proper process must be followed. The guidance for employers states that while being furloughed, employees who are union or non-union representatives may undertake duties and activities for the purposes of individual or collective representation of employees and won't then fall foul of the CJRS rules on working for your employer. And that concludes my presentation.
So thanks very much, Marc. And thanks to everyone for taking us through, firstly, the options to be considered by businesses facing financial stress, and then looking at how those processes can be conducted, and as Marc has just done, the issues around staff considerations in the current environment. What's undoubtedly true is that there's several pathways down which businesses can go when faced with financial challenges. Situation is often dynamic, and you need to be flexible and capable of changing tack as those issues develop. Most of all, seeking and then acting on advice in a timely manner is going to be critical to achieving the best outcome possible. So we've had a number of questions through, and we've got around about 10 minutes to answer some of those. Perhaps I'll start off with one for Philippa. So Philippa, the question is, what is the issue you see most often when you look at businesses, and are you seeing shareholders' aspirations change in the current situation?
Well, I think that the issue that I see the most is that people don't have a reliable cash forecast. I know I'm boring and I say that all the time, but if you don't know how much money you need per week, where it's coming from and where it's going, I think that's quite a fundamental problem. So I think that's the issue I see the most. I think shareholder aspirations, I have a number of clients who we didn't sell their business last year because they didn't think the price was quite high enough, and they thought if they hung on, they might be able to take a few dividends, etc., over the next 2 years and then sell in 2 years' time for the price. I think maybe now they're thinking that the bird in hand might have been better than what they've now got. So I think value, I think people are going to be slightly more realistic about how much they actually think their business is worth, because I do think that people, they're assessing their whole lives, aren't they, now? Not just thinking about their business, it's quality of life. How much time have I got left with my family? If I'm going to retire, how much do I really need to enjoy it? Is that a suitable answer?
No, thank you for that. We just had a couple of questions then pop up on job retention scheme. And the first one is specifically to you, Adam, so I'll let you do this one. Do you see a possible extension of the job retention scheme to September, as seems to be trailed in the press for Rishi Sunak's announcement, perhaps at a lower level, suggesting here 60 rather than 80%, as a good thing? So there's a question for you. But probably more pertinently, will September give you a sufficiently long time to enable a good sale to be completed, in your view?
Well, thank you, whoever asked that question. Firstly, on the extension, yes, I think it probably is a good thing. I think the concern is that if it came to an end in June, has that really given businesses sufficient time to adjust to the new norm? And would it have been an enormous waste of money, because there will still have to be, or are those employees who are furloughed who would have to face a more serious situation where they may be looking at redundancy? So I think some sort of extension, bearing in mind the lockdown is taking longer to come out of, I think is a good thing. Whether that gives sufficient time for businesses to be structured for what's called a good sale, I mean, that's debatable. As I say, I think that the problem is we are still in a period where there is a significant degree of uncertainty. Ian, Philip, I don't know your views, but I still don't think buyers know what is the right price and sellers don't know what is the right price. And until that level is established, I think sales of good businesses, let's say, is going to be increasingly difficult. So overall, I think it's a good thing. I think the government had to do something along those lines, because otherwise, as I say, it could have been an enormous waste of money, the furlough scheme. And I think we just need to wait and see how how the market levels out over the next month or so to see timescales for transactions. But as we say, when we're talking about accelerated M&A, I think they're going to be becoming an increasingly important process as we come out of the lockdown period, to be honest. I think now most businesses are hunkering down and are getting by using some of the government schemes. But when those stop, that is when I think these processes are going to become more and more common. And the IPs within your business, guys, are going to become more and more busy.
Yeah, I'd echo some of that, Adam. I think it's fair to say, in talking about accelerated M&A, time is of the essence, and these sorts of transactions, if they commence, will be concluded well before the end of September. Otherwise, those businesses are probably going through a more formal insolvency procedure at that stage. I think it's fair to say that there are still transactions going on in the normal corporate finance world, but they tend to be businesses that were well engaged in their process already, and also in robust sectors. So potentially things in software, communications, cybersecurity, those sorts of types of deals, anything with healthcare associated with it. So I think I'd say yes, September would be plenty of time, but I don't think that I think we're talking more about weeks on these transactions than we are talking about months. There's a sort of a follow-up question. Appreciate, Mark, you sort of answered this on the Q&A, but perhaps share a little bit further with everyone else. The question was, did you say that a buyer of business and assets who becomes the employer of furloughed employees can continue to claim their 80% of salary, i.e. does that cease upon the transfer to a new employer? So
no, you can still claim. And I did type that question in. So just to go back to the initial question, and just from an employment law perspective, if the grant under the CJRS reduced to 60% from 80%, then an employer will need to consult with those furloughed employees, because that will be a further reduction of their wages. So it's not just a given, you just announce it, oh, by the way, your grants are going to be reduced. There will need to be a formal process. I don't think that's actually been considered, and we've got these headlines. Whether they materialise later on today, we'll just have to wait and see.
Okay, thank you for that. Question that I'll have a go at. So the question is sort of going through an accelerated process, what due diligence can I practically expect to be able to complete, particularly in the current lockdown? So, you know, I think that's a fair comment. And out with of the lockdown, due diligence would be a very limited process in any event. But fortunately, I guess there are the tools that are now regularly used in virtual data rooms, as Adam referenced. And so those will get populated, but it still will be a very limited amount of data that you're likely to see in there. Chances are you can get access to management to ask specific questions, either through some form of video conference or Q&A platform through the data room. But you're not going to be able to place any real reliance. I go back to the point about no warranties. You know, this is about you taking a view and factoring that into the price. And it's really up to you to ask the questions for the information you want. I don't think you should expect that the data room necessarily will be fully populated. And if there are things that you would particularly like to see, then you should ask for them. And if they're not forthcoming, you then need to factor in the risks of not seeing that information into the price that you may pay. So hopefully that's answered that question. Adam, you just as probably a bit of a follow-up to that, and maybe from a legal perspective in particular, as a seller, what sort of information might I be looking to upload into my data room to enable a process to run as smoothly as possible?
I think we're normally, in a normal process, you're very careful about giving away sort of the crown jewels too early in the process, particularly if you're selling to one of your trade competitors. You don't want to put in all your key information around your main customers, around some of your key numbers, etc., too early in the process, particularly if they may be on some form of fishing trip or whatever. But here we're talking about an accelerated process where time and the ability to play those sorts of games isn't really an option. So I think what you want to do is put in what you see as fundamental and as key in the running of your business. So it really is the key contract, it's information around employees, it's information around your property, the lease, for example. It's stuff that is fundamental. I won't talk about the financial side of things because you guys can fill in on that, but it is the legal backbone to enable your business to operate. As I say, you need to be slightly careful and make sure, obviously, whoever you are giving access to has signed up to an NDA about giving away too much information too early in the process. But on an accelerated deal, I think you want to get as much in there as you possibly can for the reasons that you've said, Ian. There are going to be very limited warranties for a buyer to rely on. The more information you can give, I think, is going to mean the better value you get. and there will be less price discussions and negotiations further down the line. And Ian, the point you make is absolutely right. If a buyer asks for something, I think, as I mentioned when earlier on, I think the ability to respond quickly is key. And if information isn't forthcoming, that automatically asks questions and will result in price reduction. So there's a balance between putting on as much as you sensibly can, as early as you can in the process, trying to be responsive, but equally, just making sure you've responded fully to what the buyer wants.
Thanks, Adam. Marc, there's a couple of questions that have come through around consultation. One here, I was under the impression that TUPE consultation had to be meaningful rather than for 1 month. If it is for 1 month minimum prior to transfer, how does that fit in with an accelerated sale and purchase? If you've got some comments on that.
Sorry, yes. For conventional transfer, the Employment Appeal Tribunal has said for it to be meaningful, it has to be for a minimum of 1 month. However, there is what's called a special circumstances defence, which may be able to be used here, where we've got an accelerated sale and purchase.
Okay, thank you. And one more that has come through for you, Marc, is on, and briefly, sort of on the economic, technical and organisational comment you made. Is there a bit more clarity on perhaps what that might mean as terms of conditions?
Well, economical would mean the profitability or market performance. Technical, that would be the nature of the equipment or production of processes, and organisational, that would be management or the organisation structure. Okay,
thanks. So we're sort of drawing to a close. Philippa, perhaps if I can just throw the last question over to you, as perhaps a final thought around sort of options and thoughts forward. Any sort of final advice perhaps to people as they go through that options review and things to consider?
I think, but I'm a born optimist, remember, but I think that actually the key is to not panic and give yourself some time. I keep talking to people who thought they were going to run out of cash 3 weeks ago, but if you plan carefully, really carefully, by the week and look at the cash, and engage experts who can help you with that, and people who know funders. There are ways through this. So I don't think we all need to be thinking, oh my goodness, let's panic, let's sell the business, let's think of all these options. Let's just really seriously focus on the business. Let's understand it. Let's put good controls in, and let's go forward, and take this as an opportunity to come out with a better one.
Thanks for that. I think that's a good note to end on. Whilst these are challenging times, there are positives, and it's not all doom and gloom, and there are plenty of options available to you. Again, I would emphasise taking advice in a timely manner and then looking to act on it is absolutely crucial here. So thank you everyone for joining us today. It's all we've got time for. I hope you found that the webinar was useful. Next week, we're going to be running one around formal insolvency procedures and administrations and pre-pack options, and we'll send out details for that following this conclusion of this webinar. If there are questions that we didn't have time for, there's one or two, we'll make sure we follow up with you individually to discuss those. So lastly, thank you very much to all of the speakers for taking time out of their day to share their knowledge, expertise and experiences. Have a good day, everybody. Make sure you stay safe and, of course, stay alert. Thank you.